Great. Well, I think I'll make a start. Just to say at the beginning, hello and welcome to everyone who's joined us today. Also together with those who are watching subsequently on the webinar on the Brickcourt YouTube channel. This is the second in our series of webinars on the new UK Trade Remedies, and we feel very fortunate and extremely pleased to have as guest speakers today Clare, Brodie and Daniel Merlo from the Trade Remedies Investigations Directorate. They are the General Counsel and Head of Litigation, and I'm sure many of you will have interesting questions for them since they're on the inside track, so to speak, although obviously it's at very early stages in the Directorate's activities. I was going to say, please do start sending any questions you have for them or for us as soon as you wish using the chat feature on this webinar. We'll do our best to answer them. We may try and take some at the end of Clare and Daniel's talk or group them together and do them at the end, but please do send us questions. The format for today is that Clare will speak first, followed by Daniel, and I'm then going to present a short talk about issues of fact in relation to investigations, and Fergus is going to conclude with a talk about the economic interest test, and then hopefully we'll have 10 to 15 minutes for questions, but we'll see how that goes. Lovely. So at this stage, I'll pass over to Clare for her talk and the first slides, please. Thank you.
Thank you very much. Moving on to the next slide. I'm going to start with a bit of description of what are trade remedies. I'm sure many of you are very familiar with this. UK trade remedies derive from the WTO rules on trade. That's the General Agreement on Trade and Tariffs, GATT, the Anti-Dumping Agreement, the Countervailing Measures Agreement, and the Safeguards Agreement. There are three key types of trade remedy measures. Anti-dumping, where cheap exports are being dumped in the UK, injuring UK industry. Countervailing measures, which is where foreign subsidies on exports to the UK are unfairly harming UK industry. And safeguards, where a sudden and unforeseen surge in imports causes serious injury to UK producers. Safeguards are global measures and a bit different to dumping and subsidy, which are targeted to particular exporters in particular countries. Anti-dumping make up the vast majority of cases, and safeguards cases are very rare. We do in fact have one safeguards case concerning steel imports, which is an EU measure that's been transitioned to the UK. In a dumping case, we will assess the dumping margin, which is the difference between the normal value of the goods in the exporting country, i.e. the price on their domestic market, and the export price to the UK. We will look at the injury being caused to UK industry, and where we find that dumping is causing material injury, we will recommend trade remedy measures. In a subsidies case, we will assess whether there is a countervailable subsidy, the amount of the subsidy, the injury being caused to UK industry, and recommend measures where we find a countervailable subsidy causing material injury. The measures imposed and that we recommend and which are imposed generally take the form of duties and can be quite significant. I've seen a case involving up to 90% of the value of the goods. In safeguard cases, we may also recommend tariff rate quotas, which is specifying how much can be exported to the UK from each country. Moving on to the next slide. In terms of our investigations, we will carry out three types of investigation. We will carry out transition reviews of 44 EU measures that the Department for International Trade has identified as being relevant to the UK. The Secretary of State has issued notices of determination in respect of these measures, and we must initiate a transition review before expiry of the relevant EU measure. That means that these 44 cases will be spread over the next 5 years because each trade remedy measure tends to be in place for a 5-year period. So we will generally initiate in the order of expiry of the relevant EU measure. It will be quite a significant investigation. We'll be assessing whether to vary, maintain or revoke the EU rolled over measures. and so it could take sort of 12 to 18 months to carry out the investigation. The second type of investigation we will do is investigations for new measures. This generally follows an application by UK industry, and it's worth noting it's quite a significant process to make an application, as we can only initiate where there is sufficient evidence of dumping, subsidy and injury. The applicant must also show that they have met the standing test and the application is supported by a sufficient proportion of UK industry, and also that they've met a UK market share test to show that there is a UK presence for the goods concerned. In dumping and subsidy cases, new investigations, we will assess, as I've noted above, whether there is dumping and subsidy causing injury. The third type of case we will carry out is other sorts of reviews of existing trade remedy measures. This could involve looking at circumvention issues, dealing with new exporters coming into the market, or carrying out an expiry review before a measure expires. The UK has brought all of these investigations into the UK through the UK Taxation Cross-Border Trade Act and quite a raft of secondary legislation and regulations governing dumping and subsidies, safeguards, appeals and reconsiderations. And Daniel will talk more about this, and I think we've included some information on the legislation at the end of our talk today. Going on to the next slide, please. In terms of UK features, I wanted to just touch on some particular features of the UK regime. We very much follow the WTO rules, but the Department for International Trade has put in certain features that are unique to us. First of all, to note that we will be an independent expert body making recommendations to the Secretary of State on trade remedy measures. At the moment, Daniel and I are working for the Trade Remedies Investigations Directorate, which is part of DIT. But when the trade bill passes, we will become the Trade Remedies Authority, and that will be an independent body based in Reading, carrying out these investigations. We make recommendations to the Secretary of State, who will take the final decision, applying a public interest test. The Secretary of State cannot change our decision, but she can reject or veto it on public interest grounds. If she does so, she must lay a report in Parliament setting out her reasons for rejecting our recommendation. A further feature for us is a UK economic interest test. In considering whether to recommend remedies, we must assess whether the measures we are proposing to recommend are in the economic interest of the UK, which will involve looking at the economic significance of the affected industry and consumers, the likely impact of the measures on them, looking at the impact on particular geographic areas and groups, and also the likely consequences for the broader competitive environment as a whole. We also have a mandatory lesser duty rule. This is optional in terms of WTO rules, but is mandatory in the UK and requires us to assess when we are considering what measures to recommend. We must recommend the lower of either the dumping margin or amount of subsidy on the one hand, or the injury margin, which is the minimum increase in import prices that would remove the injury. This really helps to make sure the remedy is proportionate. Finally, as I've noted above, a unique feature for us is transition reviews. By virtue of Brexit and leaving the EU, we will be carrying out transition reviews to assess whether the measures should remain in place or be varied or revoked. Moving on to the next slide. In terms of our guidance, I wanted to spend a little bit of time explaining what we have set out on gov.uk. We have been in place now since October 2018, and we started our first transition reviews in February 2019. We have spent a lot of this time developing our policies and procedures and have set out guidance on gov.uk as to our procedures and processes. So looking at this page, this is a snapshot of the landing page on gov.uk, and on the left-hand side is TRID's guidance, the UK Trade Remedies Investigations Process. If you click on that link, it will take you into quite a list of guidance covering different aspects, which I'll come on to shortly. The middle box there is the Secretary of State's guidance issued by DIT, to which we are required to have regard. And finally, on the right, that will take you through into the Trade Remedies Service, which has information about all of our live investigations. So moving on to the next slide, the TRID guidance. This covers a number of areas: pre-application and how to make an application. As I mentioned above, it's quite an onerous process to make an application and set out quite a lot of information about dumping, subsidy and injury. So we have set up a pre-application office to assist applicants in understanding the requirements, and that can be contacted on the details there. We have guidance about our investigations process, about how we will assess dumping, subsidy, injury and causation, how we decide on measures, how we will apply the economic interest test, reconsideration, which will follow an investigation and before any appeal can be made of our decisions, and also information there on all the other reviews we can do: circumvention, absorption, scope reviews, new exporter reviews, and repayment reviews. Finally, on the next slide, the Secretary of State's guidance. So the Secretary of State and Department for International Trade have issued guidance to us on the following: transition reviews, guidance on injury margins and how we will calculate that minimum increase in import prices to remove the injury, guidance on the market share test in new applications, which is actually set at a very low threshold of 1%, and there is guidance there on where we can even waive it in certain cases, for example, where it's a case involving retardation of industry, and it's appropriate to waive the market share in that case. There is guidance on particular market situation, which is about using an alternative methodology to establish normal value where there is a particular market situation in the exporting state. For example, the prices there are artificially low. Finally, there is guidance on economic interest test to supplement our own guidance, and also some guidance on timelines, noting that a new investigation should take between 11 and 13 months. Transition review will take 12 to 15 months, but the guidance does note that it may take longer due to the complexity of the case, competing priorities, or due to us being in this startup phase of businesses being unfamiliar with our processes and procedures. I will now hand over to Daniel.
Thank you, Claire. Hello to everybody. I'd just like to say thank you to Sarah and Fergus as well for inviting us onto this webinar. So I'm the head of litigation at TRID and have been working extensively on setting up the litigation function and the litigation team over the last few months. But at the same time, I've also had the pleasure of being the senior lawyer on transition reviews as part of a multidisciplinary team in those case teams, which are investigators, lawyers, economists or analysts, and operational policy colleagues. And in fact, I'm on the first ever transition review, which is on welded tubes and pipes, which is something you don't often get to do for the first time. So it's quite exciting. I thought, therefore, it would be very useful if I could talk to you about the investigative process in transition reviews. And Paul, could you pass to the next slide, please? So I'm going to talk about the investigative process in transition reviews, and most specifically those of anti-dumping and anti-subsidy measures. As Claire said, we have 44 transition reviews to complete, and 43 of those are relating to those. The safeguards transition review follows broadly a similar process, although there are important analytical differences given the nature of safeguards. And similarly, new investigations follow broadly similar investigative process, although there are important differences like the initiation process, because applications are made for that. And similarly, the analysis that's required to be done in transition reviews under Reg 99A, which I'll come to later, is something unique to transition reviews that doesn't exist in a normal investigation context. So I'll take you through those bullet points there. If we can go to the next slide, please. Oh, perfect. So to kick things off on a transition review, TRID publishes a notice of initiation. That follows a notice of determination from the Secretary of State. And on the right-hand side is an example of the very first notice of initiation that we published for the welded tubes and pipes case. Now that is sent to, was published on our Trade Remedies Service, but sent to all the contacts that the case team have identified as parties who may be interested or relevant or affected by the transition review, and they are invited to register themselves on the Trade Remedies Service. As Claire mentioned, the Trade Remedies Service is an online portal to which anyone can register, either as an interested party or a contributor, and have access to the public file. So the next bullet point you'll see there is the public file. The regulations, Regulation 44 in the case of dumping and subsidy regulations, requires TRID to establish and maintain a file which is open to the public that contains all the information which we consider material to investigation other than confidential information. And I just mentioned confidential information. It's worthwhile, I think, just pointing out there are particular provisions regarding the handling of confidential information. Obviously, there's lots of sensitive information that's contributed by parties in these investigations. And so regulations set out exactly what qualifies as confidential information, whether by its nature or if it's been requested by parties. They need to have demonstrated good cause, and where information is provided on a confidential basis, non-confidential summaries of that information also is required, or otherwise a statement of reasons as to why non-confidential summary can't be provided. But otherwise, everything else will appear on the public file. If we go to the next slide, please. So here's just a screenshot of the landing page when you're looking at the active cases that we have on at the moment. As you can see, welded tubes at the bottom, that's initiated in February last year, and at the top, most recently, just a couple of weeks ago, two parallel transition reviews on glass fibres, an anti-dumping and an anti-subsidy transition review were initiated. So that's the list of the current active transition reviews. And if you go to this page, you can click on the links in the penultimate column, and that will take you directly to the public file for that transition review. And on that page, you'll be able to see all the documents and correspondence and so on that have formed part of the public file in that transition review, and so that you can access those and understand what's happening in any given case. If you register as an interested party or contributor to transition review, you will have another page which will give you access to this very same public file, but you'll have accessibility to TRID in ways of communicating directly with us. Just one thing to point out really is that I think we are the only, or one of very few, trade remedies authorities around the world to have an entirely online trade remedies portal. And we really hope that this facilitates a constructive process throughout these transition reviews and other investigations and reviews, because there are really open communication channels, and so interested parties, contributors and others can provide information with us and enter into dialogues with us in a very straightforward way. And as I say, the public file is there for anyone to access. Okay, can we go to the next slide, please? So as part of initiating the transition review, pre-sampling questionnaires will be sent out as part of the registration process. And really, pre-sampling questionnaires are just an opportunity for us to obtain some headline information before we delve into the questionnaires, which I'll talk about in a minute. And that can be particularly useful, for example, as I put here, a couple of reasons. Firstly, it may be that sampling is needed as part of the investigation where there are a huge number of interested parties. And so one of the means by which to determine a sample can be production levels, and so that information will be requested in the pre-sampling questionnaire. And similarly, the existence of a particular market situation may play an important part in the analysis of a transition review or investigation. And so we invite parties to put some preliminary information down as to whether they think this may be relevant in the transition review. So once parties have registered, these pre-sampling questionnaires have been returned and they're on the public file. Then case teams will identify who the interested parties and contributors are and issue questionnaires on the TRS. And at the same time, they will also send questionnaires to the upstream and downstream industry. As Claire mentioned in her talk, and I think Fergus will talk about later, the economic interest test is a unique element of the British or UK investigative process. And so questionnaires from those parties will be an essential means by which to obtain relevant information to enable a robust economic interest test assessment. As questionnaires start coming back from interested parties and contributors, case teams will start analysing the information in those, and there'll be a dialogue most likely with the parties. Maybe there'll be questions, clarifications, some gaps in the information that needs to be remedied. And so that deficiency process will run alongside through this dialogue between the parties. And just worth pointing out that where parties fail to respond to questionnaires or significant important parts of those questionnaires, it may be something that contributes to a determination of non-cooperation. And I just mention this because it can have significant implications for how parties' representations are considered as part of the transition review, and also ultimately the level of tariffs that they may or that we may recommend against them at the end of the transition review. Okay, next slide, please. So the questionnaires have come back. The case teams will then delve into the information and start doing kind of the meaty substance of analysing all of that information to work out ultimately whether to recommend to vary or revoke the measure. And as I mentioned at the beginning, this is unique to transition reviews. The analysis under Regulation 99A in the dumping and subsidy regulation, so relating specifically to anti-dumping and anti-subsidy transition reviews. And I haven't included the entire regulation there, but within the regulation there are two mandatory considerations that we are required to do as part of all transition reviews. So I thought it would be helpful just to flag those here. So as you can see, in a transition review, the Secretary of State must consider, firstly, whether the anti-dumping or countervailing amount is necessary or sufficient in order to offset the dumping or the importation of subsidised goods. So that's the first mandatory consideration. And the second one is whether or not injury to the UK industry in the relevant goods would occur if the anti-dumping or countervailing amounts were no longer to apply to those goods. There are various other considerations and aspects to Regulation 99A, so I would suggest looking at that. Once the analysis is done in the usual way, the information will be verified, and normally this is done through verification visits. Now, of course, in the context of a global pandemic, this has been quite challenging, and so alternative approaches have been considered and used within the case teams. I put remote there because in essence it's working remotely from our desks or homes, in this case, to verify the information provided. And then verification reports will be prepared subsequently to that. Next slide, please. So following the analysis, essentially you then come to the decision-making part of the process. Now this is a sort of three-stage process, I'd say. It flows initially from the statement of essential facts, which is an intended final determination. And the idea is to publish that and then invite further representations or responses from interested parties and contributors as part of this dialogue and collaborative process in order to essentially seek their input and try to ensure a robust and well-considered decision. Following that period of dialogue, then we make our currently called preliminary decision, which is either to recommend that the measures in place be varied or revoked. And that is a recommendation to the Secretary of State. And as I've just put there in a second bullet point, where the recommendation is that the measure is varied, that can only happen where it's found, we find that is in the economic interest for that measure to be varied. So finally, of course, the Secretary of State receives our recommendation and then we'll decide whether to give effect or not, as the case may be, to our recommendation. And the essential element her consideration at this point will be whether or not the measure is in the public interest. Okay, next slide, please. So finally, following the investigative process and the recommendation and the imposition or not of measures, there is the opportunity to challenge the decision. So we have specific regulations on this, the reconsideration and appeals regulations, and it's really a two-stage process. First of all, parties can request an internal, within TRID, reconsideration of the decision, and following that, it will be an appeal. So in terms of the reconsideration, the regulations set out in detail in schedules which decisions may be reconsidered, which essentially generally are those decisions that bring the investigative process to an end. Sets out which parties may request the reconsideration, which in essence, in most cases, are all interested parties, although that's not the case if it's a decision to refuse to initiate a new investigation, in which case it would just be the party who's made the application that would have a right to seek reconsideration. And the process as well is also set out in regulations, as well as, of course, in the guidance that Clare was referring to earlier on. At the end of a reconsideration process, a reconsidered decision will be issued. I will either maintain or vary the original decision. And it is that reconsidered decision that may be subject to a statutory appeal to the upper tribunal and tax and chancery chamber. Again, the regulations set out who may appeal. It's very similar, most interested parties in most cases, and the decisions which are appealable. Just an interesting feature of that appeal process, I think it's important to highlight, is that the upper tribunal, when considering a case, must apply the same principles as would be applied by a court on an application for judicial review. Okay, that's more or less the end of my talk. There was just one more slide I wanted to take you to, so if we could turn to the next slide. So Clare mentioned this. There is a raft of legislation that's relevant to our work. Now, in bold, at the top are the kind of key pieces of legislation. So we have the Taxation Act, and then below that, the three regulations. So the regulations related to dumping and subsidisation, the regulation relating to safeguards, and the reconsideration and appeals regulations that I just referred to. But below that sits a whole raft of further regulations which amend the primary and the regulations themselves. Some of those amendments are permanent, and some of those are transitional in as much as they amend the regulations in the Act up until the point at which TRID becomes established as the Trade Remedies Authority. So I just mentioned this really to suggest treading carefully when navigating your way through the legislation, because there are a lot of regulations to take into account. And now over to Sarah, I think.
Thank you. That's great. Thanks very much both to Clare and to Daniel for very interesting expositions. My short talk is going to look at contested facts in the investigations process with reference to the specific example of the requirement to find a material injury caused by dumped or subsidised goods, or a threat of material injury, namely that the same injury is either imminent and clearly foreseen if it's not already occurring. And that may be perhaps because it's an expiry review, or as Daniel was talking about, transition reviews, and measures affecting imports have already been in place for a while. To state the obvious, applicants for a trade remedy and interested parties supporting the imposition of such a remedy must in practice surmount a number of factual thresholds. And of course, those resisting the grant of a remedy will want to provide evidence to show that those thresholds are not met. So, as with practically all investigations and determinations, there will inevitably be context on the facts. If we can move to the next slide, or the first slide, please. Here are the questions that I'm going to look at specifically. I'm sure there are many others, but the first one, how can an applicant or interested party approach the situation of a contest on the facts? I think really that's really the question of what an applicant needs to do. What are some of the practical issues that may arise? The second, what happens where no material is advanced in support of the opposite position? Then does that simply mean, for example, that a remedy may well be granted, or does the TRID play and have to play an active part in considering the facts that may have been adduced had the party not remained silent? And finally, what scope is there for reconsideration by the TRID and or review of the facts by the tribunal? And Daniel's, the culmination of Daniel's talk referred to that. Two comments here to anticipate the final section of my talk. The use of both a reconsideration process by the TRID and a system of appeals is obviously a hybrid and is novel and unusual. You can see the attractions, in particular, of reconsideration as a process. I'm sure some of you may well have faced the situation where a regulator may have been persuadable to change a finding where the need for that change is clear, but no longer seized of the matter, and you have to go off to an appeal. That sort of problem ought to be averted. The system of appeals to the upper tribunal itself raises the issue, secondly, of how challenges to factual findings will be made and will be dealt with by the tribunal, where the standard is a judicial review one. And in that regard, the Court of Justice handed down a judgment in the last couple of weeks, setting aside measures adopted by the Council on the basis that there were erroneous findings of fact on the question of material injury. And what I was going to try to consider is what the position would be in the UK tribunals. So moving to the next slide, please. If we could move to the next slide. Thank you. Material injury. This is the particular point that I thought we may well have in mind whilst talking about issues of facts in investigations. And actually, I note that Daniel made a reference in relation to transition reviews to Regulation 99A(1)(b), where one of the mandatory questions was whether injury essentially would occur if the measure were no longer applied. So here on this slide, I've set out various provisions dealing with material injury, some of which are very briefly referred to. Unsurprisingly, given the nature of the TRID's task in deciding on remedies, legislation looks at past, ongoing and prospective injury. It defines in the schedule to the 2018 Act, Part 4, Regulations 27 to 34, 35, various matters which the TRID must decide and factors that they must take into account. Often the factors are listed in a non-exhaustive way. The TRID obviously looks at the fact of injury and also at causation. I don't think, but I'll be corrected, that there's in fact a definition of material, although there are references to where impacts are negligible at various places, including market shares. And it may be that what's intended by material is impacts which are non-negligible. On to the next slide, please. This is a non-exhaustive list referring to some of the places where injury is of relevance. That is to say, it plays a specific part in the investigation process according to the legislation governing it. You can see from the first two in Schedule 4 that these are couched in terms of whether the TRID is satisfied that the application has shown sufficiently that there is evidence that the practices complained of have caused or are causing injury. Obviously, the onus on that stage is on the applicant. Different considerations apply, presumably in a transition or expiry review. The fact that it's for the TRID to be satisfied or not satisfied may obviously make it more difficult to challenge any decision on a precedent fact basis at that stage. That is to say that there may be an error in relation to taking or refusing the investigation. The second 2 points on this slide relate to findings that the injury is negligible and an affirmative determination, respectively. You'll see that the investigation has to be stopped if the TRID determines at any stage that the injury is negligible. And in relation to the final point on that slide, where it says that the dumped or subsidised product has caused or is causing injury, it's presumably important to bear in mind there that injury includes a threat of material injury. In other words, it can simply be imminent and clearly foreseen. And this is the point that I'd like to go on to on the next slide then, please, if we can move to the next slide. So the first bullet refers specifically to Regulation 28, which looks at the question of a threat of material injury, and the threat must be clearly foreseen and imminent. There are a number of factors that may be relevant, whether or not there's a likelihood of substantially increased imports, freely disposable capacity of the overseas exporter, what the other export markets are and what's available, whether export prices will suppress prices of like goods in the UK or increase demand for the exports, questions of inventories, and the trade effects of any subsidy. And Regulation 35 makes the important point that it's important to for the TRID to assess whether other known factors have caused or are causing injury to the UK industry aside from dumping or subsidy. And if so, injury from those factors must obviously not be attributed by the TRID to the dumped or subsidised imports. So those are some of the issues that may arise in relation to this question of material injury. If I could move on to the next slide, please. Thank you. So the first question that I posed at the beginning relates to the question of contested facts, and there are a number of considerations here. The first is how far, if only non-confidential versions are supplied in general, is a party able to grapple with the other side's material. It seems quite likely that when dealing with impacts on businesses, future projections, strategy, costs, other export markets, and so on, there will be matters which are confidential to the party supplying the material. This is, of course, not unusual for economic regulation, and non-confidential versions are something that most of us are very familiar with. It's possible, I think, in the guidance and the regulations here to use, for example, ranges of figures or percentages in setting out sensitive trading information. And it's also true that the Commission has been dealing with anti-dumping and anti-subsidy cases in the EU for a number of years, so the problems are clearly not insurmountable. However, it does seem from looking at documents on the public file so far in relation to the transition reviews that a number of matters are regarded, not, as I say, unsurprisingly, as commercially sensitive. And it will inevitably make it more difficult to grapple in detail with opposing views. And I'm sure a modus operandi will have to emerge to enable this to take place. The second point is whether or not it's possible to reply to facts that the applicant side disagrees with prior to the desk review and the statement of essential facts. I think it's envisaged that there should be a fairly iterative process, and Daniel referred specifically to the fact that there's an online portal. But I suppose the question is whether or not it is necessary to wait at any stage until, or whether or not there's a cut-off before the signing, before the finalising of the statement of essential facts, or whether there can be a process of replies backwards and forwards. The factors in favour of that sort of process, where you have an iterative response, obviously, are that it should improve the precision and the accuracy of the statement of essential facts, but the trade-off may well be detriments to the ability to move on without delay. The fourth bullet, taking it slightly out of order, when is it possible to seek a hearing before the statement of essential facts? The guidance on the Trade Services website suggests that hearings are most likely to be suitable after that statement has been provided in dumping and subsidy cases. And there is at that stage an opportunity to comment on the information provided and the calculations in the statement before a final determination is made. And I wonder, or pose the question, is whether or not it is in practice going to be possible to seek hearings at the earlier stage. On the third bullet, this question of additional information, as Daniel mentioned, that the TRID has obviously stated it will verify figures based on desk review and the information they have through visits, currently conducted remotely, but hopefully in future in person. And they may also look to supply facts available from other sources. So, for example, you could think of published price lists, secondary sources such as official import statistics, customs returns, and information from other interested parties. And the guidance, I think, says that secondary sources are to be included, but obviously taking particular circumspection. And the final bullet, this question of whether or not you can seek hearings and supply information and comments after the statement of essential facts. Obviously, that does seem to be built into the process, but I suppose one question that might arise is there a scope for multi-party hearings, and how in practice will it be ensured that there is equal treatment for parties who have and who haven't sought hearings. If I could move quickly to the next slide, please. So what if there's no contradictory evidence? The point here to make is it seems to me that it shouldn't be assumed, if no information is received to counter the views being put forward by an applicant or interested party, that obtaining a remedy is simply a foregone conclusion. As I mentioned earlier, and also in the first webinar, there is this process whereby the TRID can have regard to facts available to it from secondary sources and obviously from other interested parties, where it has to make determinations, for instance, on whether the injury that has occurred to date is imminent and clearly foreseen. It'll be tasked with taking a view not just on what UK producers' market is like and whether it's vulnerable to injury, but also on matters such as capacity, inventories of foreign exporters, markets they sell to, and so on. And so information sourced from secondary sources is likely, I think, to be quite important. The second bullet is a process point, and it will be important that applicants do realise that there has to be an opportunity for and suitable time allowed for observations to be made by an opposing side, even if no material seems to be forthcoming. And if those opportunities are not available, then the TRID cannot make an affirmative determination on dumping and subsidy and the fact that it's caused or is causing injury. On to the next slide, please. As I said earlier, and I'll go quickly over this, the use of a reconsideration mechanism is a novel one, but it does give an opportunity to provide further information and to have a reconsideration by a separate team. And so I think it's likely to prove useful and, although novel, probably welcomed by everybody. And on to the last slide, please. So here was the question about appeals to the tribunal on factual issues applying a JR standard, and in particular, will the approach of an appellant to try and look at precedent fact issues or reasonableness, failure to take into account relevant considerations. I think the point here is that there'll no doubt be interesting questions about the ability to challenge what may be perceived as any mistakes of fact. Questions that are likely to arise are whether or not there was any misappreciation or misapprehension on the decision maker's part about what the statute required before a determination could be made. So whether there was any precedent or jurisdictional fact issue that can be treated as a point of law on an appeal, or where matters shade more clearly into the assessment and weighing of economic factors, the decision would obviously shade more into areas that can be challenged only on reasonable grounds. There will be questions about whether or not there's been any mistake as regards a material fact or whether conclusion was unsubstantiated by evidence, and it is possible that traditional JR routes might avail here, for example, failure to take into account material consideration. And just very quickly at the end, the Court of Justice case referred to, obviously on a different system, can turn the setting aside of a regulation based on the fact that certain conclusions were unsubstantiated by fact or were contradicted by other facts. The court concluded the council had wrongly considered that there was a threat of material injury and pointed to various failures and various factors that it had failed to take into account. So in summary, bringing all that together, I think although the determinations of the TRID will, I have no doubt, be adopted with very great care and thoroughness, appeals may well begin to be brought in the upper tribunal dealing with matters such as how a review takes place in the next few years. And I'm going to pass to Fergus. Thank you very much.
Thank you, Sarah, and indeed thank you to our colleagues at TRID. I'm going to quickly look at the economic interest test, which, as we've heard from our colleagues at TRID, is one of the critical aspects in any trade investigation into anti-dumping, anti-subsidy, and foreseen import searches. We'll see in a moment how presumptions arise or don't arise. This is clearly going to be one of the areas that will differ from that which has happened in the past when the UK was part of the EU, and therefore trade policy was governed by essentially EU law, and the regulator was the Commission and Council and the court. The relevant court was the General Court, with an appeal to the CJU. In the EU legislative framework, there is a union interest test, which is, and I quote, based on an appreciation of all the various interests taken as a whole, including the interests of the domestic industry and users and consumers. And that's Articles 21.1 and 31.1 of 2016 of the anti-dumping regulation and anti-subsidy regulations, respectively. Sorry, Paul, if you could go to the first slide, so you could, I'm just looking at the overview. In the UK's legislative trade framework, as we've seen, the parameters are set out in a more detailed and indeed localised fashion in the Taxation Cross-Border Trade Act of 2018. It is unique in its detail and very different, not only to the position in the EU, but extremely different to the position in the US and Australia, where there is no such test. The fact that the test is unique and detailed means that it will undoubtedly take time to bed in. And for the remainder of my contribution, I'll endeavour to highlight areas that may give rise to debate going forward. Can I have the next slide, please? So the presumption, as I've mentioned, there is a difference in the manner in which the presumption that the EIT has been met is actually operating. As made clear in the guidance that's already been mentioned from the Department of International Trade, and that was updated most recently on the 20th of January of this year, the EIT is presumed to be met in dumping and subsidy cases, but not in other cases, where the presence of the dumped or subsidised imports which are causing harm has been established. Unless, and it's important to recognise this, TRID is satisfied that the application of measures is not in the economic interest of the UK. As I've said, no such presumption applies in safeguard measures which look at unforeseen surges in imports. Now, could we, before I pass to the next slide, as I say, in that slide, the TRID will only consider that the EIT is not met if the negative effects of any remedy are disproportionate to the need to remove the actual injury. Could I pass to the next slide, please? Now, there are three queries that I think arise from this existence of a presumption in dumping and subsidy matters. The immediate problem is that it's predicated on actual injury. If there is actual injury, the presumption applies. However, as identified in the guidance I've referred to, the economic interest test not only looks at actual industry, but obviously also how a future trade remedy might affect the injury being caused to the domestic industry, in other words, looking forward. Now, that's very different from the existence of actual industry. And the guidance seeks to answer this particular issue by stating that when the presumption applies, i.e. when there is actual injury, the relevant Directorate, Trade, will only consider that the EIT is not met if the negative effects of a putative remedy are disproportionate, as we saw in the previous slide. Now, it's not clear from that statement whether when determining that proportionality test, the criteria for the test, the ordinary criteria for the test will be applied, or whether there is a different test. So the queries that I've set out there are, will the rebuttal in terms of rebutting the presumption include political factors such as foreign policy issues? And as I've set out already, the difference between actual and future impact of the trade remedy, and what criteria, as I've said, will be used to determine the proportionality issues. Are they going to be the same, as would apply for an EIT to be established or to be met, or will they be different? Next slide, please. Paul, could I have the next slide? Thank you so much. If the trade finds following an investigation that dumped or subsidised products are not causing injury to the UK industry, then the prior EIT assessment will not be included in any final determination. Now, you might think correctly that that is pretty obvious, because if there's no actual injury, there can be no EIT to meet. However, I would suggest that it does pose a potential problem in terms of judicial challenge. Just imagine, as I set out there in query 4, a situation in which a complainant is faced with such a situation in which there is a final determination that there was no injury caused by the relevant imports. The complainant then might wish to challenge that decision, but would in effect be precluded from challenging the preliminary earlier EIT assessment because it won't form part of the final decision under challenge. Next slide, please. Procedural matters. Now, much of the data relevant to the EIT will be highly technical and potentially subjective, particularly in relation to the future effects, which you've seen is an important part of the EIT. One such future effect has been identified in the guidance, which is how much the price of or demand for downstream products might change as a result of the measure in question. Now, in competition cases, such evidence or equivalent evidence would be the subject of expert economic evidence reports. Now, if that were to be the case, it would be important to allow interested parties to at least challenge such evidence. At the moment, there doesn't appear to be a mechanism for that, and maybe that's something that can be looked at going forward. Another procedural matter is that of confidentiality. The guidance states in terms that all information relating to the EIT assessment will be placed on file and made available to interested parties and contributors unless a confidentiality issue is raised. There is no mention there of non-confidential being produced for scrutiny, and any full refusal of access to file on grounds of confidentiality would obviously be very concerning. So that covers off queries 5 and 6. And finally, could I have the next slide, please? The Secretary of State's role. And this picks up on a point that Daniel made, a very important point, about the plethora of secondary legislation in this area. And we also have the fact that the trade bill is not law yet. It's all a little bit not completely bedded down, can I say that? Why am I raising that? Because Section 20, subparagraph 3 of Schedule 4 to the 2018 Act, in its original version, permitted the Secretary of State to refuse TRID's determination that the EIT was met, where he or she was satisfied that the determination was not one that the TRID could reasonably have made. In other words, Wednesbury unreasonable. High test. Now, that has changed through the taxation, I'll take a big breath here, brackets cross-border trade, close brackets, Act 2018, open brackets, appointed days, number 4, and transitional provisions, close brackets, open brackets, modifications, close brackets, open brackets, EU exit, close brackets, regulations 2019. Now, that has taken away the Wednesbury unreasonable test and replaced it with a pure public interest test. So the question, query number 7, is that would that allow political issues to be taken into account, such as foreign policy considerations? One could imagine perhaps a trade agreement being negotiated by an independent UK with a third country, and that third country was subject to trade measures in the form of anti-dumping duties, let's say, which have been ported across, or a new investigation had been started, would the Secretary of State in those circumstances potentially take into account the larger issues, political issues, when determining whether the imposition of duties on the relevant products would be in the public interest? Something to watch. Final slide, please. Thank you. So, given the critical nature of the economic interest test, the lack of precedent and the uncertainties, this could definitely be an area targeted in legal challenges to trade determinations. Thank you very much indeed.
Thank you, Fergus. I think, Bill, if you have any questions, please do send them through. I wanted to ask an initial one, actually, which relates to the EIT and to Clare and Daniel, but it obviously involves other parties, sort of other industries, trade unions, employee groups, and so on. At what stage do you start gathering information from them, whilst also conducting an inquiry in the industry itself, the affected industry itself?
Daniel, do you want to perhaps answer this one? Because I know it's something that builds into the questionnaire process.
Yes, exactly. So that primarily, like all the other information you want to seek in investigations, is principally sought to be obtained through the questionnaire process. So upon the issuing of questionnaires after registration, there will be specific questionnaires to the interested parties, asking them for more information about the upstream and downstream industry and supply chains to help us further identify who we might seek information from. And then questionnaires are sent to those industries to get their input on that. So yeah, it's as comprehensive an approach as possible, and seeking kind of input from relevant people who can point us in the right direction, as well as kind of using our own research and so on.
Great. Could I just pop in? Clare, you mentioned, and I mentioned, the fact that the trade bill is still a bill. It's not an act. Do we have any info as an intelligence as to when we might get a Trade Act 2021?
Nothing definite. I think we are confident that it's making good progress, and we do hope to have the bill complete soon, and we are certainly within TRID making preparations for the bill to come into effect. We have a chair designate, Simon Walker, in post. We have our CEO, a new CEO, Oliver Griffiths, who's joined us as a CEO designate, and so the arrangements for the TRA are very much coming into place, and we hope for royal assent soon.
Super. Thank you so much. Now, I'm not sure whether we have any further questions. We may have a couple of ones. But another question that I had that came to mind when I was talking was, what are the communication links with other regulators like? Because obviously in say, the competition field, the CMA will have good communications with other regulators throughout the world, both in Europe and elsewhere. And I was just wondering whether a similar sort of network, like the European Competition Network, is in place or is envisaged to be in place between you and other regulators.
I think we're very keen to develop those connections. We were very fortunate that we had some colleagues from the Australian Authority, the Australian Anti-Dumping Commission, helping us in our setup phase. We had one of their very experienced investigators join us during our first year to share their experience of internal process and procedure. And at the WTO, I think twice a year, they have an event called Rules Week, during which governments, but very often authorities, attend to discuss detailed matters on dumping, subsidies and safeguards. And we do hope to be able to take part in some of those discussions about the future direction of trade remedies, as well as sharing our experience and indeed learning from the experience of others very much.
Great. That's very interesting. Sarah, I know that the time is 2 o'clock. Can I squeeze in one final question to our colleagues? Thank you so much. You're in charge. I mentioned the issue, and I think Sarah mentioned confidential information, non-confidential versions, and the ability to access file and rights of defence, etc. Are there any thoughts or experience that you can share with us and with our attendees in relation to dealing with confidential information and getting responses to it from other parties?
Daniel, I might hand this one over to you. I mean, we very much have our digital portal, the Trade Remedies Service, through which parties access, make their submissions and access the case and the requirements in our legislation regarding a public file. But Daniel, do you want to say a bit about how it's working in practice?
Yeah, sure. So exactly that. Parties in general should provide their representation to us through the portal. They have the private communication channels to do that with us. And the expectation is that they provide confidential and non-confidential versions of the representations. And as I pointed out in the regulations, there are specific kind of rules set out, around confidential information. But generally speaking, well, I think the rule is that if parties provide confidential information, they must also provide a non-confidential summary of it that we consider adequate as per the regs, or, as I say, a statement of reasons as to why that's not possible. So, I mean, that's as a process that's been kind of ongoing in all of our transition reviews, and it is a process that has to be given some thought. The information has to be reviewed carefully. Confidential information has to be treated and handled carefully. It's, as I say, it's an ongoing process, but and equally, I think it's worth pointing out similar rules apply when you go to appeal. For example, say the upper tribunal rules have been amended to enable the handling of confidential information in the context of a challenge to a decision at the tribunal.
That's very helpful. Thank you very much indeed. I think we're now 3 minutes past 2. Sarah, I'm in your hands.
Yeah, I think probably we should wrap it up there. But I do want to say a huge thank you, particularly from us to, and I'm sure from the audience, to Clare and for Daniel for coming along and sharing all their thoughts and their experiences so far. It's a fascinating area, and I'm sure it'll be watched with interest by a lot of people as things develop. So thank you very much. And just to say, I think to anybody, if you do have questions arising out of any of the things that have been said, do feel free to contact us through Chambers, and we can see if we can take some of those up in due course. So thank you very much to the panelists, and thank you for listening. And say goodbye for now. Thank you.
Thank you.
Bye-bye. Thanks.